now it is my pleasure to introduce to you our presenter today on this incredibly important topic that is impacting all of our members of all sizes across all industries. Linda Bond Edwards is a partner in the Tallahassee office of Rumberger, Kirk, and Caldwell. And Rumberger, Kirk, and Caldwell, of course, is one of our great Chairman Circle members. And we're so thankful to them for the resources and the information that they provide to us. And because of our relationship, they were able, on short notice, to not only get us a presenter on this topic, but what I call the presenter on this topic, and that's Miss Edwards. Linda devotes her litigation practice to the representation of employers in the private and public sectors in matters involving employment and labor issues. She has more than 20 years of practice experience in labor and employment law and more than 10 years of corporate human resources experience. So she really does know from a company level what it is that you're going through. Ms. Edwards is a county and circuit civil mediator certified by the Florida Supreme Court. She received her law degree from Florida State University College of Law and her Bachelor of Science degree in Business Administration from the University of Tennessee. She has written numerous articles on and spoken at public and private seminars addressing employment law issues, including wage and hour trends, discrimination, workplace harassment, and bullying, and alternative dispute resolution. And Linda, thank you so much for being here with us, and I'm going to turn it over to you.
Thank you. Good morning to each of you. It is my great pleasure to be with you this morning. As Samantha said, this is an important topic, not just the changes, those are important, but also just the ongoing increasing litigation on the Fair Labor Standards Act. And so my conversation with you this morning, and I do say that it's a conversation because I want you to feel free to ask questions, to gather as much information as I'm able to share, and so that all of us have a much deeper and greater understanding of what's happening with the changes in this law. I mentioned to some folks last night that the Fair Labor Standards Act is one of my favorite employment laws to talk about. And that's because there's such an opportunity for employers to take proactive steps to prevent lawsuits. And unfortunately, some of the organizations who have people in this room have been the subjects, if you will, of significant lawsuits and have paid out millions of dollars in settlement for overtime law violations. And we're going to, unfortunately, talk about a little of that a little bit later on. The Fair Labor Standards Act is actually one of the oldest employment laws in existence. It was signed in 1938 at a time when manufacturing was to a much greater degree than we might see today. But it was also at a time when when employers were working employees just an incredible amount of time and not paying them any overtime for the hours that they were working. And so this law was enacted to basically pay people a premium for the premium time that they were offering to employers. That still is the case today. It has two very simple requirements. One is that you pay people minimum wage, and that you pay them overtime for all hours worked over 40 in a work week. And so with those two simple requirements, one might wonder, why in the world is there so much litigation? How could those two simple requirements cause so much activity? Well, we'll talk about that as well. The other two areas main areas that the Fair Labor Standards Act addresses is youth employment and also record keeping, and we'll talk about that also. One of the other thing, just by way of overview, for a minimum wage is that the federal minimum wage is $7.25 currently, and however you think about whether or not that needs to be increased, that's what it is currently. And the state of Florida has just announced the increase in the Florida minimum wage, which will take place in January of 2017, where it will go from $8.05 per hour to $8.10 per hour. Now we start to look at some of the areas that can cause all of this litigation. You would think that everybody would know what work is. but not so much, because much of the litigation has come about with what is actually working time. And many employers have struggled with that. The U.S. Supreme Court has looked at this issue with regard to what is work. And if you think about it in very simple terms, it relates to is sweat time. What is the person actually doing? Are they doing anything? And the next question to ask is, does it benefit the employer? And when you answer those two questions, it helps you kind of hone in a little bit more on why the litigation may have come about because of the question of what is hours worked. And there are questions that come up around waiting time. And waiting time is usually categorized into two different areas. Are people engaged to wait, or are they waiting to be engaged? If they're engaged to wait, it simply means that you have told them to report to work. Maybe you don't have work for them to do, but come and see. If they come in and you tell them immediately leave, no problem. But if they're just waiting around, whether you have work for them to do or not, if they're waiting around at the employer's direction and are not free to leave, you have to pay them. And the other issue is on-call time. What does that really mean? Well, again, how much control are you exerting over that person's ability to use their own time? If you, for example, for those employers that place employees on call, if the person is so tied down to your restrictions that they can't leave, they can't do anything that they want to do, you have to pay them. There's been litigation over that. Meal and rest periods. Employees would have you think that you owe them a lunch break and a rest period. You don't. There's nothing in the law that requires you to provide a lunch period, excuse me, or a rest break. But if you do, then you have to be sure that you adequately pay people. If you provide a rest break that is generally 20 minutes or less, you will have to pay them, because the courts have ruled that that's really insufficient time for anybody to go and do something on their own time. If you allow lunch breaks of about 30 minutes or more, you can provide an unpaid lunch break. There are some industries that don't provide lunch breaks. They automatically deduct lunch periods. If your employer, whether the decision is yours or not, but if your company automatically deducts lunch breaks, don't do that. Just don't do that, because you don't know whether people actually take the time to take a lunch or not. If you tell them, well, just take a lunch if you can, I'm going to deduct from your pay whether you take one or not, don't do that. They will probably gather together the rest of their coworkers and file some sort of collective action against you. Training time. If you have employees that are required to have some sort of certification or some sort of specialized training, and you provide that training on site for them, that is usually compensable. It's not compensable time if they do it after work time. You are not required to pay them to continue to keep their certifications that are necessary. Travel time also presents some particular issues for people, because if you, for example, if you have employees that are going to a conference, and this is non-exempt employees, if you have people who are traveling to a conference, the passenger is not paid for the time, but the driver is. The regulations say that time spent as a passenger traveling is not compensable work time, and sleep time is only compensable if you require people to work 24-hour shifts, and this is usually for folks in public safety, usually firefighters, paramedics, those kind of folks. Overtime pay. If you start with the premise And this is where, if you start with this premise, it makes the rest of it a little easier to take. Every single person in this room is entitled to overtime. All of us are non-exempt employees until our employers apply whatever exemption applies to us. And that is generally where employers make a large number of mistakes, and that is misapplying the exemption. Labeling persons as exempt, which means that you are exempt from the overtime provisions, labeling them as exempt when they really ought to be non-exempt and therefore entitled to overtime. For those persons who are covered by the Fair Labor Standards Act, and these are non-exempt hourly employees, they must receive 1.5 times the regular rate for all hours worked in a work week. And it's a simple calculation of dividing the hours worked by the amount of money that's paid. The exemptions exist, and there are 3 main ones. They are the executive, administrative, and professional exemptions. There are also some exemptions for outside sales. Again, very narrowly construed by the courts. If you have made the determination that the person is exempt, be very sure that you are correct, because if you are incorrect, that means that you owe that person for overtime for all the hours that they've worked over 40. The other thing, that's the general labeling of the exemptions. In order to get to the exemption, there are 3 main things that employers ought to look at. One is the salary basis, and that's the change that's going to take place on December 1st. The salary basis test means that the person is paid at a minimum salary level. Currently, that amount is $455 per week. That's the first test they have to pass. The second test is they have to be paid on the first one is a salary basis. The salary level is the amount. The salary basis is that they are paid the same amount every pay period, regardless of the quality and quantity of the hours that they work. We get questions all the time. Well, this person didn't work a whole week, or, they're only working 30 hours per week, and what can I do? Can I fire them for attendance? What can I do? Well, if they are a salaried employee, the answer is probably no, not based on attendance. But there may be another basis for taking some sort of disciplinary action. The third and probably the most critical area that employers need to take a look at when determining whether or not someone is exempt, and that is the job duties test. Why does this person's position exist? Why is that person's job there? What are their actual duties? I think that many employers have gotten to the level of sophistication, at this point at least, where they know just calling someone salaried is not enough. Just giving someone a certain job title is not enough. That you really do have to dig in and look at what the actual job duties are. Now, the changes. There have been some questions about whether or not the changes are actually still on track to take place December 1st of 2016. With all the information that I've seen, yes, the changes will take place. It's being attacked in a couple ways. One is there are some 21 states that have filed a lawsuit in the Eastern District of Texas to try to halt the changes. There has been no ruling on that, and so because there's nothing just yet to halt it, it's going to go forward. The other way that it is being attacked, there are 2 House bills in the U.S. House, 2 House bills that have been filed, and we could be sure that those will get done by December 1st, so that might halt it. Probably not. So it's probably going to take place, or the changes are still going to be effective on December 1st. The big deal, and I know that for members of your organization and also your national organization strongly opposes these changes, and many employers do. The U.S. Chamber of Commerce has also filed a lawsuit to halt the changes because of the tremendous impact that it will have on retail operations. There's been much press about the impact that the changes will have on retail operations, and it's because of the dramatic increase in the minimum salaries. As I mentioned, the current minimum is $455 per week. That will go to $913 per week, almost double what people are being paid currently. If there is any good news about the recommended changes, it is that there is a rule that was set that would update the minimums every 3 years. And the reason why the change is so significant this time is because the minimum has not been changed since 2004. That $455 per week was set in 2004 and hasn't been changed. So you think about the changes in the cost of living that might have occurred since 2004, and particularly for those persons who are at the lower end of that scale. There is a provision in the salary basis or in the salary level test that addresses highly paid non-exempt employees. And that, excuse me, there is a special provision for highly paid non-exempt employees, and I hope you all don't mind if I take my jacket off, it's a little warm. For highly paid non-exempt employees, and it basically said if you have a non-exempt employee, and these are usually folks that are or that may be the executive assistants or folks like that, to executives for corporations, those folks may be at salary levels above $100,000. The regulations say that those folks can be classified as exempt, even though their duties may be non-exempt. The new changes increase that minimum to $134,000 rather than $100,000. Just one thing, if you have hourly paid employees, nothing happens. If you have exempt salaried employees who work no more than 40 hours per week, and they are at the new minimum, and they meet the salary test, no change. If there are salaried workers who are not exempt and already receiving overtime, there's no change. Now, let me just kind of stay at this place right here for just a minute. You can pay non-exempt employees a salary. And I know that it is a fairly common practice by some retailers to pay people based on what's called a fluctuating work week. It can be done if done correctly. Later on, I think there's a slide where one very large retailer was not properly applying the fluctuating work week standard and were hit with a significant back pay award. If your employer, if your company uses a fluctuating work week, it works like this. If you pay them a salary, and maybe you have some employees that work 35 hours a week, some that work 38, some that work 42, some that work 45, and they make the same salary, you can pay them that salary so long as it's clear what you're paying. So long as it's clear that the salary that they receive is intended to pay for all hours worked up to whatever point that you pay them. And it's clear that it's intended to even cover, and if they work above 40 hours, that the only thing that you owe them above that salary is the halftime for the hours over 40 that they've worked. And so you can utilize that. And again, it's certainly a way that you can manage how you pay people, but you've just got to be extremely clear that it's clear to the employee how you're paying them. But again, as I said, the regulations do allow you to pay people, to pay non-exempt employees a salary. They don't all have to be hourly. Yes, sir.
In that particular pay for fluctuating work week, they also have to punch a time card or create a time record, do they not?
You're exactly right. As a non-exempt employee, you do have to keep accurate records of the actual hours worked. That's, again, sometimes employers fail to do that. It doesn't have to be electronic. It doesn't have to be in any particular form, but you just got to have the employer, the burden is always on the employer to make sure that you have accurate records of the hours worked. And I can assure you that if you don't have accurate records, the employees will have some real interesting records that they will produce. Some of them, you wonder why they're still standing because they've worked so many hours. So you do have the burden to keep the records of the hours worked. Just a little bit on the primary duty. Again, keep in mind that it is what the employees do that can satisfy any question about the exemption. It has to look at what they do on a daily basis, where the major emphasis is on the character of the employee's job as a whole, not just the title. You know, I don't know if any of you remember the show Cheers, and if you do, you remember that Woody was a person who worked at the bar after Rebecca and Rebecca was one of the managers at the bar, and Woody comes in and he asks Rebecca for a raise, and she says, "Oh, that's not a problem. I thought you were going to ask for a new title." And he's like, "Well, what do you mean?" And she says to him, "Well, you know, I don't mind paying people extra money, but I can't just give titles to just anybody." He says, "Oh, well, just keep the money. Give me the title." It's not that kind of situation when you make the determination about exemptions. The titles don't matter. It really is what the person is doing. There, again, the executive exemption, and the only reason why I'm spending time on this is because this is the area where employers really fail to make the right calls as to whether or not people are exempt or non-exempt. And so the first one is executive, and trust me, I won't go through all of these, but the PowerPoint will be available so that the information can be available to you for your later review. Pretty significant job, or that an executive has. Again, they manage the enterprise. They're usually called manager, director, something like that. Again, the titles don't matter, but that's just a normal title for what those folks are called. They have significant responsibility. They have the right and the authority to hire people. Excuse me. They have they are basically the decision makers. They direct the work of two or more other people, and they're even if they don't have the right to make the decision, their recommendations are given strong weight, and are usually followed by the person who does have the right to make the decision. Again, some other tasks that your folks do that manage the enterprise. Again, some additional duties that your folks who meet the executive exemption might have. All of you might have heard about the lawsuit that was filed against Home Depot by the human resources people. So, if you're going to treat anybody right, it ought to be human resources people. And here's why the human resources people were claiming that they did not meet the exemption. They claimed that so many decisions were made at levels above them that their job duties had basically been reduced to nothing more than paper pushers, that they did not have the authority to do a whole lot, that many of the hiring decisions, work that would normally be done by a person in their level, was being done by someone else. Home Depot either agreed with them or decided that they didn't want to fight it. And it was I think it was about a $15 million settlement because they had misclassified their human resources professionals. I'm sorry, yes, sir.
Are you familiar with the Aldi case, ALDI, where Aldi's a lot like some of the people maybe in this room have what we call working managers? I mean, if we've got a produce manager or we've got a grocery manager, they could be unloading a truck, and they could be doing, they may be culling the rack, and it's all part of managing the department. And the key is how much of that they do. Well, the Aldi problem is that in their case, they're a limited assortment store, and that manager is like all over the place all day long. And I just never heard how that case came out, and I think it would be an important case for retail to see what that was. And I just wondered if you might have known what that is.
I'm not familiar with the Aldi case, but I'm familiar with the Family Dollar case, which was kind of similar. And unfortunately, and Family Dollar's been through it a couple times. They had their managers doing everything, really, including sweeping the fronts of the stores. They had responsibility to do that. They had responsibility for stocking the shelves. They operated the cash register. They did basically everything. And that was the bulk of what they did. Their allegation was that the real management work in terms of hiring and things like that were done more by the regional managers rather than by the store managers, and that the store managers really did not have the authority to interview and to make decisions about who was hired. Maybe the regional manager took their recommendations into play, maybe they didn't. Family Dollar, the first Family Dollar case back in 2008 actually went to a jury, and the jury made a pretty significant award on behalf of the plaintiffs. And this case occurred in Alabama, but the jury award was affirmed by the 11th Circuit because they did appeal it. The second time, they just settled it. They settled the case, and the second case actually happened in Colorado. And that was, the case in Alabama was 2008, and the one in Colorado was 4 years later in 2012. I don't think that they've gone through it again since then. I guess after a few $1 million of payment, they perhaps made some changes in how they manage their stores. But yeah, you do have to be extremely careful about what managers actually do. Now, it's okay if they engage in what's called non-exempt work, the unloading of the trucks, perhaps the running of the cash register, if they do it on a voluntary basis and as needed. I mean, it's just a reality that there are going to be absences. You're going to be short, excuse me, short employees. You're going to get busy. Things are going to happen so that the manager sees a need, steps in, does what they need to do, and then goes back to attending to whatever other management duties or responsibilities they may have. Nothing wrong with that. But if 80% of their job is unloading trucks, stocking shelves, things like that, then it raises a little bit more of a question about whether or not they're actually exempt employees.
As a follow-up, would the salary for a fluctuating work week with the halftime and you have the right agreement and all those things in place, would that satisfy the Department of Labor as far as having that kind of person? I mean, because we have retailers out there that's got that scenario.
Oh, sure. If they are making the adequate overtime payments, yes, it should satisfy the Department of Labor.
Thank you.
Again, just a little bit more about those, and here we talk about those concurrent duties. If it says they have to do the exempt work has to be more than 50% of what their jobs are. If it becomes 60% non-exempt and 50%, or if it becomes 60% non-exempt, 40% exempt, you got a problem. And all it takes is one manager, one employee to say, oh, this isn't right. And on a bad day, they could probably convince a few other people to join in with them. Again, just a couple of examples of how that could happen. Those are the kinds of things that constitute those concurrent duties. Use of manuals. Most of you have manuals about how to do something. The manuals that are referred to in this examples are like maybe what as lawyers we use case law, we use the case books, we use the rules of procedure. We follow those rules. We know what they are. For accountants, there are the principles of accounting that people may refer to, things like that. But it requires learning in order to be able to use and understand the manual. Not just, if you need to ring somebody out, here are the steps that you take when you do it. The administrative exemption is also one that is misused because sometimes people misconstrue the administrative exemption for administrative people. Not the case. There are two key things that you want to look at. The first one that is directly related to the management of the general business, and the second one, these words: exercise of discretion and independent judgment. Those two things, if all your person does is what you tell them to do, again, getting back to those Home Depot human resources managers, they had no authority to exercise any independent judgment or any discretion or independent judgment. They were just said, if the person is A, B, C, and D, you hire them. No reason to go through any sort of evaluating the information that they have and making decisions. These are typically areas of the organization where you find people who fall under the administrative exemption, and these are people who, again, who exercise discretion and independent judgment. They don't just fill out the paperwork, if you will. If they have the ability to bind the organization, if you give them the ability to make contracts with others, where they have to evaluate what's going on, they evaluate whether or not it's a good business decision. Those are the kind of decisions that they need to make. So a hand somewhere, yes.
Do these apply to all employers regardless of the number of employees they have?
Yes. For the Fair Labor Standards Act, there is not an employee number that applies. If you have gross sales and revenues in excess of $500,000, it applies to you. If you are a nonprofit, that $500,000 does not include membership fees, it does not include donations, it does not include sponsorships, things like that. Unfortunately, for non-exempts, where they get caught is the second part of the test as to whether or not it applies is if you engage in interstate commerce. And unfortunately, we order things over the internet. We call and we order things from out of state. And the regulations have found that that then drags the individual under coverage, and therefore the employer is still tied to the regs. So it's real hard to find an employer that doesn't fall under the provisions. Again, we look at what constitutes discretion and independent judgment, and the authority that the employee has to have. The next one is the professional. Again, just calling someone a professional does not bring them under the exemption. The professional exemption generally applies to doctors, lawyers, engineers, accountants. There's also, and I'll show you a list in a minute of what actually or other job titles that fall under that professional exemption. But again, these are usually folks that have some advanced knowledge that is gained by a period of prolonged study, and usually, and it says specialized intellectual instruction. There might be some questions about whether or not some people have actually done that, but that's usually what meets the professional test. And just there's also some misnomers, some misapplications of the professional exemption by looking at people who have college degrees. Just the fact that you require someone to have a college degree to perform your job does not make that person exempt. They could have a degree in basket weaving or something else that might be incredibly interesting, but really doesn't raise the position to the level of a professional. But the degree in and of itself is not what gets the person to become a professional. It is the job duties that they perform. If you here are some examples of professions that do fall under that professional exemption, and these are usually not related. Well, if people have degrees and they are engaged in this kind of work, again, not just relying solely on the job title, but at the actual, if they are performing work in these particular areas, then yeah, they do fall under that professional exemption. The last exemption is for computer-related operations. This kind of came about under the changes that were made in 2004 to include computer-related functions. And again, it has to be folks who are really engaged in the design, development, analysis, serious computer analyst folks, not your person who tells you, well, if something's wrong with your computer, turn it off and turn it on. They probably don't fall under that exemption. The next area, again, they have to, this did not change, the minimum did not change for the computer professionals. Theirs has already been at that level, was at that level prior to the proposed changes. Outside sales. This one creates some problems for folks because the first question that's generally asked is, well, what about inside salespeople? It says outside sales. So generally outside salespeople do not fall under the exemption. Outside sales is just that. These are people that are paid by commission. They don't have to meet the salary test, but they do, that the second part of the description, that they customarily and regularly engage away from the employer's place of business. There was some action that came about back in about 2012 that related to folks who were inside sales in financial institutions, and folks who would try to, they were mortgage brokers pretty much. And the Department of Labor basically said these folks are not subject to the outside sales exemption. They may be entitled to another kind of exemption, but they are not outside salespeople, and you have to pay them accordingly. So they do have to truly be outside salespeople in order to meet the test. Now, there are some exceptions. Again, they have to be paid the same amount, and their salary is not subject to reduction, but there are some exceptions to it, fortunately. You can make deductions for full days of pay, not partial days, full days of pay for personal reasons other than sickness or disability. You are allowed to make those deductions from a salaried employee's pay. You can also make deductions, again, full days, not partial days. If they are sick or disabled, you can substitute that absence or that pay for that absence with leave time to keep their salary the same. Deductions for salaried employees. Up until 2004, employers could not couldn't, for example, give salaried employees unpaid suspensions for disciplinary actions. Those are now allowed, so long as it is clearly explained in your policies and procedures, and it's the same policy for everyone else. So you can suspend your exempt employees for disciplinary actions. Again, we talked about the deductions for pay. You don't have to pay employees a full week's pay, because you do have to pay employees a full week's pay if they work any day in that week. You have to pay them for the week. But if they don't work at all, you don't have to pay them. If they can take unpaid leave under the family medical leave, they can do that. I hope that all of you, again, just, people, you can lose the exemption, which means that you now owe people for all of the hours that they've worked if you lose the exemption. Hard to do that, but it is possible. Hopefully, all of you have some sort of policy that tells your employees that you intend to pay them for the hours that they work, and that you've made a good faith effort to comply. And that's important, because if you're ever sued under the Fair Labor Standards Act, there are two times for statute of limitations. One is 2 years, the other is a 3rd year if the violation is found to be willful. A willful violation means that you knew or should have known better, and you didn't do anything about it. And so by advising people in your policy manuals that you ought to, or that you intend to pay them the way that they should be paid, at least cuts off your statute of limitations period to 2 years and not 3 years. Again, just some simple policy language, if you don't already have some. Do encourage employers to absolutely audit your practices, audit what you're doing to ensure that your positions are properly classified, that you are making proper deductions from your hourly employee pay. One of the things that some employers do is think that they can just make deductions from hourly employee pay if the employee owes them money. For example, if your employees have uniforms, if they have any of your property and they leave, you do not have a right to hold their last paycheck, nor do you have a right to make a deduction from their pay to pay you for whatever you think that they owe you. You can do that if you have proper authorization from your employee. And even in that instance, you cannot make deductions to any employee pay that causes that employee's pay to fall below the minimum wage. And so auditing your pay practices allows the employer to see where there might be areas where they're vulnerable. Because I just believe that those employers that have been sued under the Fair Labor Standards Act probably thought that they were doing it correctly. They probably thought that they had good practices in place until one of their employees ran into the wrong plaintiff attorney. And I will tell you that often Fair Labor Standards Act lawsuits don't start out that way. I had a conversation with a person in another professional organization who said that the way that they got sued, and they ended up in an $800,000 settlement for their employees. One of their employees had a car accident, totally unrelated to their work. Had a car accident. Went to the lawyer to talk about his car accident. Had no idea, had no intent whatsoever to sue that employer for a wage and hour violation. But the plaintiff attorney's intake questionnaire just asked a whole litany of questions, one of which, where do you work, what do you do, how are you paid, and that's how they stumbled into that lawsuit. Sometimes it's more intentional, but it doesn't always have to be. So again, auditing will help you identify some of those areas where there might be some vulnerability. We talked about just generally keeping records, that you have to do that, and I recommend that you keep them for about 3 years. Again, that's the statute of limitations period. Don't have to have time clocks, but you do have to have an accurate method. And here are just some records that you need to keep. Should have postings. I'm sure you've all done that. Just some common errors that some employers make. Assume that all employees that are paid a salary are exempt. Improperly classifying people, as we've talked about. Not paying hours actually worked, and that includes, again, the donning and doffing, which means that if you require your employees to wear some sort of specialized equipment or clothing, uniforms or whatever, and they can only wear it inside the facility. If you require them to change clothes after they get there, that time is compensable. So, and if they have uniforms, things like that, you cannot make those deductions. Some steps to ensure compliance, and I've been saying this kind of all along. Review all of the positions to see if the exemption has been applied, even before you start to look at whether or not you need to make changes. Quick way to do that: when you look at how people are paid, look at who's below the new minimum. Once you make that determination about who's below the new minimum, look at what they do. Look at how many hours that they work. If they're not working more than 40 hours, there's really nothing that you need to do. That person automatically becomes non-exempt. And they automatically become non-exempt because they no longer meet the salary test for exemption. If they are going to be non-exempt, you do have to begin to keep records of how many hours they're working. If there are other changes in your benefits or whatever that you need to make, you need to do that. Now, the second thing is when you make that cut about who's below the minimum, look at how many hours that they're working. If they're working no more than 40, no problem. If you know that they're working more than 40 hours, and you may or may not know this because most employers don't track hours of exempt employees, so you may not know how many hours your exempt employees are working, but you have some idea. The managers and supervisors have some idea about who's working how many hours. If you have people that need to work more than 40 hours per week to get their jobs done, then you have to make a decision about whether or not you want to increase that person's pay to the minimum or whether you want to hire a part-time person to make up the time that person would normally be working the extra hours. And the other thing is, really look at what they're doing in those extra hours. Are they really, does the job really require all that many hours? Or is it a job that if the person only had to work 40 hours, could they get the job done? So it really is a time for evaluating what your employees are doing. Yes.
When you're looking at salary, are you solely looking at the wages earned, or do you look at any other type of compensation in terms of benefits or healthcare or anything like that? Does any of that go into the calculation of salary?
For non-federal contracts, no. If you have federal contracts, you can add some of that stuff in. But if you're just straight employee, no, it's strictly wages. Now, you can include bonuses if it is promised. If it is promised, and by promise I mean it's not discretionary. Yes.
What's really scary is there was a restaurant chain, I'm not sure of the name, so I won't say it, but where the managers were only allocated so many hours, period, okay? And they asked, or he or she asked, for the people to stay over so they could clean up. And I mean, this is the scary part because the district manager or the top manager probably did not know that. I mean, you'd like to say they didn't know it. But the manager on duty, the person in charge, did that, which created a huge problem.
Absolutely. Absolutely. That working off the clock, it's actionable. Employers will get sued and they will lose.
Even if it's 5 or okay, listen, give me an extra 15 minutes, just don't get this done.
Right.
I mean, that's where you can get in trouble pretty quickly, I think.
Right. Right. My time is getting close, so I'm going to talk fast. And again, I'll leave all of this information so that you can look at it later. But just the key points that I want to make is, one, make sure your positions are properly classified. I keep saying it. And I'm just going to fast forward because I want you to, these are just some employers that have been sued, that have had to pay overtime. And the one that I want to just quickly mention is for Pizza Hut. And this is just a lawsuit. They're being accused of not paying or not reimbursing their employees for expenses for delivery. And the effect of that is it causes their pay to fall below minimum wage. They're paying a minimum wage, but by the time these employers make all these deductions, it causes them to fall below. Again, we talked about Family Dollar. This is a small employer down in Fort Lauderdale. Again, they were only 77 employees, and you think about the impact of an employer that small having to all of a sudden come up with $240,000 to pay back pay because they were not paying overtime. Publix, unfortunately, again, had some, didn't quite calculate the fluctuating work week correctly. This is a Tennessee case, Rite Aid, 21 million, because they improperly classified their assistant managers. Foot Locker, again, $7 million in settlement. And this is one of the ones that I wanted to just show you, the effect on the retail, or how the retail industry has been affected. 26% of the cases in the retail industry. And this is from, this is through 2015. This one is, again, not quite at the top, but significantly affected by and this is where the lawsuits are coming. Failure to pay proper overtime and misclassification. That's why I keep harping on, make sure your employees are properly classified. Still continues to do that. So again, thank you. Thank you, thank you. I'm sorry. Yes, go ahead.
Of course, this is destroying my current structure, to say the least. Can I require somebody that is hourly, if they desire to leave the workplace to pursue a personal matter, to clock out and clock back in and that sort of thing?
Absolutely.
So it has to be work, if I can demand that, and if they don't, what kind of action can I take?
If they violate a policy, you take the same action as they would if they violate any other policy. If that's your policy and your policy is legal, you have a right to take disciplinary action. You know, I've had a number of employers who will say employees can't work overtime unless they're approved. Well, unfortunately, if they work overtime and you didn't approve it, you still have to pay them. You can discipline them for not following your policy, and I know it sounds counterintuitive, but you can do it.
Okay. I suspect small folks like me, I'm not the big guy, you know, with a dozen employees or so, we probably, almost all of us have somebody that's misclassified. We've been paying pretty good salaries. We need to get the work done. It takes, you know, this amount of time. So we're going to have to reconfigure a lot of people back to an hourly. That's going to be a pretty tough psychological jump for them and that sort of thing. One, feel like they've been demoted substantially back to hourly. And we've allowed them a good bit of freedom to do those personal things that they do and not affect their salary up to this point. So I'm probably going to have a dramatic shift in attitude and everything else. And man, this is going to be a...
Think about it like this. It may be, think about how quickly you're going to spend, how much money you're going to spend in overtime relative to increasing their pay to that minimum. Because you may burn through that overtime so quick that it might be more cost effective for you to just adjust them to the minimum and continue to let them work the way it's just a...
The minute you're close to this hourly minimum number, the vulnerability to challenge to whether I am really an exempt employee or not, because of all of those classification issues, becomes more real, and where an attorney would take up the case with ease and to meet all of the tests very thoroughly. I've got some that wouldn't meet all the tests and that sort of thing. So that becomes not an option. So I've got to shift them back into hourly and wrestle with all of these issues of the personal time that they've been taking and the freedom that we've allowed in the past might not be so free in the future. So.
Yeah.
Tell them when you have your meeting, tell them to blame it on the House of Representatives. And the President, blame it on the feds. This is the only option you got.
The only positive that I can even fathom out of this whole thing is the fact that it will require employers like yourself to look closely.
Very close.
Do we really need this guy to be 45 hours? Can he get it done in 40? Can he get it done in 38? I mean, those are the things that I see are positive, because we get fat, dumb, and happy with people over a period of time, and we just let it go. And that's the only positive that I can glean from any of this.
I did hear from another company that was trying to evaluate how to do this, and they said that they found a way in recruiting, millennial workers to spin it as a positive, is that a lot of millennial workers, your younger workers, want work-life balance. And so they spun it as a positive of, we expect you to be at work only this amount of time. When that time is up, we expect you to go out and live your life. And so for the millennial workers, they tried to find a way to spin it as a positive and as an answer to work-life balance. That doesn't necessarily address the workforce that may exist within your companies now,
No,
but
that's
those
a
that
good
are
alternative.
attracting a younger workforce, that may be a way to spin that.
You can only work 30 hours and then you're not to pay in benefits. So what we'll do at the end of the day is we become a really wonderful third world country.
One question, and then Randy's gonna get, put out the hook.
If you're asking somebody who's non-exempt to travel to another city by airplane, so they drive to the airport, fly on a plane, then report to work in another city, do you think the travel time and the airplane time is compensable time?
No, because it's time, if it's during the regular work, a lot of ifs. If it's during the regular work day, the time spent as a passenger is not compensable time,
What about when they're driving to the airport?
possibly. But possibly.
Maybe the drive there was
So it's hard for me to say we're possibly going to pay you. Let us know when you get back.
Thank you all. I'm sorry it took so much time.